Hi, my name's John Moon. I'm an attorney and owner of the Moon Law Firm, and this is our YouTube channel. The idea behind this YouTube channel is to be an interactive forum, a place where you guys can ask your legal questions and get general answers to those questions. Now, the reason why I said general answers is because a YouTube video can never and should never be considered a substitute for licensed, competent counsel representing you on your case. You need an attorney looking into the specific facts and details of your case and the law that applies to them in order to get good advice and the best possible outcome. If you'd like to submit a question to be answered on this YouTube channel, write to me at jmoon@moonlawfirm.com. That's jmoon@moonlawfirm.com. Each week I'm going to try and pick a handful of questions that I can answer, questions that I think are most interesting or would be most helpful to people viewing these videos. So with that said, this week I've received a few questions and we're going to go ahead and go over them now. All right, this is one that I get asked pretty regularly, and it's generally speaking, if the officer that wrote me the ticket didn't get the make and model of my vehicle right, is that enough to get the case dismissed? And generally speaking, no, it's not. In Texas, there's a legal document called a complaint that typically needs to be filed in order to charge you with an offense like speeding or running a red light or other traffic ticket kind of offenses. Now, the complaint does have to meet certain legal criteria or it is defective. However, the make and model of the vehicle is not one of those legal requirements. So if the make and model of the vehicle is wrong, if they say that you were driving a Toyota and you were really driving a Honda, or if they say that the year is 2010 and it's really 2008, those typically are not going to be defects in the complaint enough to get your case dismissed. Might be good cross-examination information for the officer or something along those lines for trial purposes, but in terms of it being a legal defect, it's probably not enough. This next one isn't one that anybody asked me in email about, but it's one that I think is an interesting topic. I think it's worth talking about, and hopefully it'll be helpful to somebody, and that is, what do you do if you've been served? What do you do if you've been sued? Now, guys, I know that I'm going to start sounding like a broken record, but if you get sued, the first thing that you need to do is find an attorney. Find somebody, if you're tight on cash, find somebody who can offer you a free office consultation and just give you some general pointers. But hire an attorney. Find an attorney that could take your case pro bono. Find some kind of legal aid that might be able to help you out. But again, I don't care if it's in the municipal court or the Supreme Court. You need a lawyer to represent you on your case and give you the best advice and help you obtain the best outcome possible. Now, if you get sued, you're going to be served, which means you're going to be visited by a process server or a constable, and they're going to give you a stack of papers and tell you that you've been served. In that stack of papers, there's going to be a copy of the lawsuit and a sheet that has some general information about the lawsuit and some general instructions on what you need to do now. The main thing that you need to do if you get sued and if you get served is you need to be timely about filing a response. Now, in Texas, you typically will have the Monday following the expiration of 20 days after you've been sued to respond. You have 10 a.m. on that Monday. Now, what does that mean, 10 a.m. on the Monday following 20 days after you've been served? Well, what that means is you take the day you were served, you count 20 days from that day, and then it's the Monday after that at 10 a.m. That's your deadline. So you have to file an answer by that deadline or else you are in default. And if you're in default, that means that the party that's suing you, the plaintiff, can get a default judgment against you. Now, what that means is that they get to go to court, they get to put on their facts, they get to put on their evidence, and the judge only hears their side of the story. Oftentimes, they can get a default judgment against you. And if you ignore that, default judgments can be very, very, very difficult to do anything about after the fact, after they've been rendered by the court. Sometimes there's nothing you can do about them. So it's very, very, very important if you get sued, if you get served, to be proactive about finding counsel and getting a response on file so that you aren't just handed a judge, so that the plaintiff isn't just handed a judgment against you without you doing anything about it. It's very important to find an attorney, and it's very important to respond. This is another really good question, and it's kind of an interesting one because there's really two questions involved in it, and that is, when do I need to have a contract? In Texas, there are instances where you probably should have a contract, but it's not absolutely necessary, and then there are instances where you must have a contract in order for there to be a valid and enforceable agreement. So let's talk about the first one. When should you have a contract? Well, in Texas, oral agreements are binding in a lot of situations, so you don't necessarily need a written contract, but you should have one. And the times where you really ought to have one are times where you don't feel comfortable losing the money or property involved in the transaction. The bottom line is that a verbal agreement is very difficult to prove. It's very difficult to substantiate in court, and oftentimes you get a he said, she said kind of thing going on with the terms of whatever agreement it is if it's not written down. If you're concerned at all about losing the property or the money involved in the transaction, then you really ought to have a written contract. And let me give you an example of what I'm talking about. I have a guy that comes and cuts my yard every week, and we have a verbal understanding that each week I'm going to pay him, and each week he's going to come and cut my yard. Well, in that situation, I would have to have an ongoing contractual agreement with this guy if I wanted to have a contract for him cutting my yard. And in that type of a transaction, it's just not worth it to me to write up an agreement or anything like that and have him sign it and me sign it and, terms and all that kind of stuff. It's just not worth it. I don't mind if I end up paying him one day and he doesn't come back to cut my yard. I'm not happy about it, but it's also not the end of the world. However, if I had a transaction where, I was concerned if I were to lose out on that money or that property that was involved, that's really a situation where it might be worth your while to have a lawyer draft a contract. I've seen a lot of, home done contracts, and oftentimes they're not as specific as they need to be. They're not as good as they need to be. And a lot of times a bad contract or a home brewed contract can cause as much litigation as no contract at all. So if you're worried at all, or if the transaction kind of arises to more than, a normal face-to-face kind of transaction, then you really need to have a contractual agreement to protect you. Now I want to talk about the second kind of situations where a contract is required to have a valid and enforceable agreement. In Texas, we have a statutory provision known as the Statute of Frauds, and what that says basically is that if you want a valid and enforceable agreement in certain situations, you have to put that agreement to writing and have it signed by all the parties. I'm going to go ahead and put that provision up on the screen right now while I talk about it. So, as you can see, there are about 8 different situations where a contract is going to be required by the Statute of Frauds. And some of these are fairly common. The purchase and sale of real estate, which is provision number 4. A lease of real estate for a term longer than 1 year. So if you want to lease a house or lease a commercial building for longer than a year, you have to have a contract or else it's not enforceable. If you verbally agree with somebody to sell real estate, it's not enforceable unless you put it to writing. There are a few other provisions here, and that is in Chapter 26 of the Texas Business and Commerce Code, if you want to go look it up. But for the most part, if you have the provisions that I think are going to apply to most people most often are going to be if you are going to buy or sell real estate, if you're going to lease real estate for longer than a year, and also if you are going to have an agreement that is not performable within 1 year from the date you enter into the agreement. So those are the types of things that are going to require a contract in order to be valid and enforceable. Again, guys, if it's anything above just, kind of an amount of money or a type of property that you wouldn't mind losing if the deal goes south, get a contract. It's going to be worth it. It's going to save you lots of money in the long run. And as always, get an attorney who knows what they're doing in these kinds of cases. Find somebody who's knowledgeable and get them to help you out with it. This next question is one that I get asked a lot, and the basic nature of the question is, if I acquire a piece of property and I put it only in my name, can my spouse get it when we divorce? And the answer to this question is that it depends. You're going to find that I answer a lot of these questions with it depends. And the reason that is kind of goes back to what I said at the beginning of this video, which is you really need an attorney looking at the details and the facts specific to your case, because for every general rule I'm going to give you in these videos, there's typically going to be an exception, and you really need to have an attorney in order to navigate those general rules and exceptions and all of that. I can't really do that in this video because we just don't have that kind of time to go in depth on every possible scenario of Texas marital property. So for the purposes of answering this question, I'm going to go with a very, very, very basic example. Let's say that the spouses get married in 2006, and then let's say they acquire the property in 2008, but the property is only put in one spouse's name. The answer to that question is the spouse will probably be considered a community property asset and be subject to a just and right division by the courts. Let me back up a little bit. In Texas, we typically have two kinds of marital property. There is separate property and community property. Now, there's also a third, which is mixed, but we're not going to get into that for the purposes of this answer. Separate property is typically property that was acquired by a spouse prior to the marital relationship. Community property is typically anything that was acquired after the marital relationship and had begun. And when I say after the marital relationship had begun, I mean any time from the day the marriage occurred up until the day of divorce. In Texas, even if you've been separated from your spouse for a while, you are still potentially subject to that community property finding if you acquire something even after you guys have been separated. So you've really got to be careful there. Now, if an asset is community property, so let's take the example that I gave. Spouses are married in 2006, property is acquired in 2008. It's during the marital relationship, but it's only in one spouse's name. That single fact is probably not going to be enough to make that property a separate property asset. It will probably still be considered a community property asset. And what that means is the community property assets are subject to division by the courts in a manner that the court deems just and right. So to kind of wrap it all up in summary, if a couple is married in 2006 and they acquire property in 2008, but it's only in one spouse's name, it's probably still subject to division by the courts, and the other spouse, who's not a named owner of that piece of property, can still have access, may still get that piece of property in a divorce. I really enjoy doing these episodes because I think that the subject matter is pretty interesting, and I really genuinely hope that these episodes help somebody understand the law or understand their situation a little bit better. These episodes really only work if you guys are participating, and I want to encourage you to send me questions. They don't even have to be anything that is a legal issue that you're currently dealing with. If you are currently dealing with something, you probably, as I've said 100 times before, you probably need to get an attorney, and whether it's me or whether it's somebody else, just get an attorney that can help you out, because it's really, really, really crucial to getting a good outcome in your case. But really, this is for questions about if you've ever been curious about something, or if it's something you've always wondered about, or commonly held belief about the law. Feel free to drop me a line, drop me an email at jmoon@moonlawfirm.com. That's jmoon@moonlawfirm.com. It would probably be easiest if you kept your questions to the practice areas that I am engaged in. It's primarily in the areas of traffic ticket defense, so if you get a speeding ticket, stop sign ticket, something like that. Civil litigation, which is any dispute over money or property. and family law, which is divorce or paternity suits, child's issues, child support, visitation, rights and duties, conservatorship, adoptions, things along those lines. So if you have any questions, let me know at jmoon@moonlawfirm.com. And if you have an immediate matter, if you need immediate legal assistance, feel free to give us a call at 713-999-9398. That's 713-999-9398. I look forward to hearing from you guys, and I'll see you next week.